Now, in the meantime, Julius Abure says he has filed an appeal and a stay of execution against the ruling of an FCT High Court, which had barred him and others from parading themselves as leaders of the party. He says by the appeal and the stay, he is now back as national chairman of the party. In fact, the court, that's the FCT court, has actually granted that stay. But take a listen to what Julius Abure said not quite long after the FCT, of course, granted him that stay of execution.
It has become imperative for me to address this press conference to properly put the legal issues surrounding the leadership of the party in their proper perspective. It is pertinent to state categorically and clearly that the Labour Party has no faction in the party. Labour Party has only one leadership, and that leadership is the National Working Committee that is led by me, Barrister Julius Abure. Recall that some few members of the National Working Committee boggled themselves into the office and appointed themselves, precisely 4 of them, as officers of the party, acting upon a restraining court order, an ex parte order granted by the FCT High Court. However, having appealed and filed a motion of stay and all other processes, and since the lower court is now seized with jurisdiction on the matter, I and my colleagues, earlier restrained by the FCT High Court, have now assumed our constitutional duty as national officers.
Well, now let's go back to that issue of the legal pronouncement now by the Federal High Court in Kano State over the Labour Party candidate in Abia State, that's the governor-elect of Abia State, and other candidates that the party fielded in Kano State as well. Joining me now to discuss further on that issue is lawyer GT Ogunye, who joins us from Abuja. Thank you very much, sir, for joining us on the program. Give me your take very quickly, sir, on this judgment, on this ruling now by the Federal High Court in Kano.
Well, thanks for inviting me, DEJI. Generally, this has been my long-standing view. Power tussle in our country has become very rancorous. It was even murderous at a stage in the early days of democratic experimentation, when a number of party sittings were being felled by assassins' bullets in Nigeria. Notably, the sitting Attorney General of the Federation was murdered in an incident that was not an armed robbery incident. Clearly, that murder was politically motivated. So that's why I say that it was murderous, even at the stage. So tussle for power has become very rancorous in our country. And because our law courts are the arbiters, they are the forum for adjudging matters. So political battles usually shift to our courts. And unfortunately, our judiciary, although it's done its best in the circumstances, has not discharged itself creditably well on the whole, in the face of this inundation of our courts by political actors. So from time to time, you begin to see cases and judgments that you look at and then wonder, where is this one coming from.
So are you in essence
therefore,
saying
my position,
this ruling falls into that category?
Specifically, therefore, in a moment you get the drift or the sense I make of this judgment. The judgment that has just come out, Kano Court, in its purport, has the effect of affecting what had occurred in Abia State, for example, Kano State, Abia State, And so the NJC over time has declaimed this practice of courts outside the state that has the territorial jurisdiction over a matter, assuming jurisdiction in a matter and then giving judgments that impact things outside his territory. Although we're told that the Federal High Court has one jurisdiction, but there are authorities that have said, no, that's not quite correct. If a matter, a cause of action arose in a place or a state where there is a Federal High Court, why will you leave that Federal High Court to go to other states? For example,
but then this is not just about the governor-elect of Abia. I mean, don't forget we also have candidates from Kano involved as well.
Exactly. So if you have candidates involved in Kano as well, you limit the reliefs you are seeking to the candidates in Kano. That's the point I'm making. But let me just say clearly that in summary, this decision is for me a strange decision. The decision flowing from a case, an originating summons that was filed on May 11th. May 11th, originating summons. Today is May 19th. So look at the
speed.
Yes, we want the court. We want the court. We want matters to be expeditiously determined. But look at it. This is akin to the other case that took place in Umaya the other time, when a surrogate of the outgoing Attorney General or an ally filed an action, against the Electoral Act, an action that was decided with the speed of light.
Now, okay. but then beyond the issue of speed, let us look at the legal matter involved here.
But that's one of the issues.
Yes, Section 77 of the Electoral Act.
Here,
yes,
the legal matter involved here are a number. Number one, election-related matters are broadly categorized into two categories. You have pre-election matters. You have post-election matters. Petitions to challenge the election of a candidate in the general election, or the issuance of a certificate of return to that candidate, is a post-election matter. While pre-election matters are those cases, flowing from primaries of parties regarding issues before an election, before a general election.
And this is obviously a pre-election matter.
Tribunal will have been constituted. Now, by Section 285 of the Constitution, a pre-election matter must be filed within 14 days of the occurrence of the events is challenged. For example, if there is a primary that is conducted on a certain date, within 14 days of the conduct of the primary, with which a person is dissatisfied, a member of a political party, an action will have to be filed post haste in court. Now, this action, on the face of it, was filed by originating summons on May 11. Those persons whose candidature are being challenged, they become candidates before the general election. That's number one. So I don't need to talk too much on that because we are not a court of appeal here, although this is an important public interest matter. And so that's the number one issue. The number two issue there is the issue of jurisdiction I talked about, divisional jurisdiction, things occurring in other places, being subsumed under the jurisdiction of a federal high court in Kano for the purpose of litigation, and then for the court to then adjudicate the matter. And finally, if you ask me, is the issue of, yes, parties have the right to go to court, but that political party is facing or pursuing a presidential election petition right now. And so all these things are occurring. So how would that impact on that political party? And so generally, the UN me invited, I was being invited for this. I was just, because it gets to a stage you just get tired of speaking on these matters. Yes,
but
I
understand. I understand you. I mean, the whole thing. It's there's just trouble everywhere, trouble everywhere, especially with the Labour Party. But let me ask you this: when you look at Section 77 of the Electoral Act, and especially subsection 2 and 3, I mean, and I think I'll read it. There you have subsection 2, which says every registered political party shall maintain a register of its members in both hard and soft copy. Then subsection 3 now says that each political party shall make such register available to the commission not later than 30 days before the date fixed for the party's primaries, congresses, or convention. Now, if a party does not comply with this, should that amount to the party now losing, as in, could it be assumed that that party has not fielded a candidate in an election? What could
I'll answer your question. Deji, I'll answer your question directly. But I'm saying that by our substantive law and procedural law, there is something that is called statutory limitation periods. So an action could be alive today, by tomorrow it could have been statute barred. So that if you brought an action, if you filed an action in respect of that subject, the court will say you slept on your right. This matter is statute barred. The period within which you ought to have ventilated your grievances, if any, that period was long gone and over. The point I'm making is that even when it has to do with the issue of register, that a claimant or a plaintiff may want to use as a pedestal to nullify the candidature of some candidates. The question will be, when did you realize that? When the primaries were conducted, didn't you understand at that time that there were no register? So if you did, why didn't you bring the action within those 14 days? If you didn't, well, it is too late for you to now raise those issues. That's the point I'm making, because it is not the practice in law for causes of action to be eternal. To be eternal. There's the limitation periods. So the appeal would be otherwise if it were open to somebody, for example, election petition within 21 days. So if you don't bring your election petition within 21 days, You can't bring it again, because if it were open to people to just bring an action whenever they feel like bringing an action, it would then be possible for election to be concluded. Then after the person elected has spent 2 years or 3 years out of a 4 year
I understand
term, then somebody then comes forward and then say, oh, I just realized that he was not properly elected, so I'm filing a petition. That would be ludicrous. That would be irresponsible. That would be totally illogical and illegal. That is the point I make, because we are talking about occupancy of political offices. We are talking about governance. And there is a presumption that once elections are conducted, you don't want things to be truncated. We talk, it's a delicate process, okay? And so that's why in our laws, you have provisions governing this. So the fundamental contention here for me, beyond the issue of whether if there is no register, should they be considered to have been properly elected, and can that be a kind of nullification, is that, look, even if that were admitted, the law is saying that once you don't raise it within those 14 days, it's like what we see in church during a marriage, ritual.
Yes.
Is there anybody here
that has any
objection to this solemnization of marriage? First time, second time, third time, it is over. It is more or less like that. That is the point I'm making. And so for a court in May, close to inauguration, to now go back to a pre-election matter that ought to have been filed in June 2022 or thereabout, when primaries were being conducted, to say, oh, there were no register, it leaves much to be desired. Yet we are not a court of law.
Yeah.
We're just talking about public enlightenment and public intellection. But this, usually are things. I'm passionate about the integrity of the judiciary because I'm a lawyer and I'm an officer of the court. So I don't want the judiciary to do anything that will make the ordinary people on the streets and non-lawyers, that lawyers call lay people, to cast aspersion on the integrity. It pains me, regardless of whether I had anything to do with the matter or not. So,
all right, Mr. Aguiyi, I'm afraid I think we just have to leave it there.
These issues are plain.
I get your point.
Are plain enough.
Yes.
To everybody. That's the point. Yeah.
Yes, I get your point. Thank you so very much for joining us on the program, and thank you for your elucidation there. Thanks for your time.
Yeah. It's my pleasure.
All right, we'll take a short break, and we come back. Anambra State is in the eye of the storm again. That's what we'll be talking about next. Stay with us. Don't go away. Opinions are free. Facts are sacred. But truth is universal. How, in practical terms, can we, for instance, de-escalate the tension?
President must see himself as the president of the Federal Republic.
We know where the enemy is. 3 places. The Lake Chad Basin, the border area between Nigeria and Cameroon, and then the Sambisa Forest.
On DEJI360, we give you a complete dose of everything. Opinion, facts, and undiluted truth.
I hardly believe what politicians say in this part of the world.
A new Nigeria is possible, a future is possible.
We delve into the issues, dissect it so that you can understand it, and use it to take action.
I don't think there's any need for any governor to look for grant for ranching.
DEJI360, dissecting the issues.